Thank you very much, Professor Paulus, for the constitutional view. My topic is more the simple law, right? The development of German Betreuung and hospitalization law. Certainly, it is a topic that many of those are interested in here, the colleagues from the other land and the other countries as well. I can't be open. I have to pick up certain issues that right now are maybe particularly intriguing or important. And this is what I thought I should be doing. Talking about practice right now, the Federal Supreme Court is not that far away from practice, you know. When I was a young local court judge, I did Betreuung cases, incapacitation, curatorship in those days. I mean, I know what it has been like and know what it is like in the local courts. Right, on the matter itself, as per 1st of January 1992, the Betreuungslaw in section 1896, etc., replaced the previous provisions on incapacitation with subsequent guardianship and the frailty curatorship. Court cases since 1 September have been laid down in the family law. The material Betreuungslaw, since taking effect, and 6 further laws, has been not insignificantly changed and made more precise. In jurisdiction of the Federal Court of Law, many initial doubts and interpretation questions have been sorted out on the basis of highest jurisdiction of the BGH and the Federal Constitutional Court. More amendments are in the offing, as Professor Paulus just highlighted. As an introduction, a few words on the need for the legislative reform of 1992. The law of guardianship and custody for adults had been shaped by the tension between welfare and deprivation of liberty. Since the Federal Civil Code took effect, the major terms on the incapacitation and of guardianship had not been changed much. But the application of these legal concepts had indeed changed in court practice over the years, not insignificantly. The original standard case of adult protection after incapacitation because of mental illness or feebleness, because of wasteful spending or pomposity or drug addiction, had declined considerably, but regionally differently. Instead, curatorship had been appointed against the will of those affected with comprehensive effects. Incapacitation always leads to loss of legal capacity or limited capacity, action capacity of the person concerned, irrespective of whether in the natural sense they were or not. Ordering curatorship, however, had no impact on the legal capacity to transact. Irrespective of the earlier division of adult protection, the law of guardianship for adults and the law of curatorship in large parts had no specific provisions but referred to that law for minors. For this reason and many other reasons, the outdated regulations had to be reformed. The fundamental reform occurred with the law on the reform of the Betreuungsgesetz of 12 September 1990 to revise guardianship and curatorship. Now, some preconditions on legal representation. Legal representation on Section 1896 and subsequent of the Civil Code combined the previous incapacitation into one concept of adult protection, and has now specifically laid down the preconditions. It can only be ordered, the legal representation, if an adult, because of a psychic illness or a physical, mental, or psychic impairment, cannot manage his own affairs in full or in part. Jurisdiction by the Federal Constitutional Court shall, according to that, no person shall become the object of state intervention. Everybody has the right to design his life according to his own ideas, unless the rights of third parties are affected. The state does not have the right to educate or to better or to prevent a person or prevent him from harming himself. Where the person is able to define his own will, you must not appoint a legal representative against his will. This caused the legislator, as of 1 July 2005, in Section 1896, to specifically include a Para 1A, that is new, which specifically provides for that. Jurisdiction of the BGH says that the term of free determination of will is tantamount to that of legal capacity in Section 104, number 2 of the Civil Code. In its core, the two decisive criteria are the capacity of discernment of the person affected and the capacity to act along that insight. If one of the two elements is lacking, there is no free, but only a natural will. The underlying findings on exclusion of free will because of illness must be substantiated by an expert opinion, says the BGH, and in the scope of a personal interview must have been verified. Let me address the legal representation and subsidiarity against an enduring power. All the guardianship and hospitalization law depends on necessity. Legal representative may only be appointed for a certain sphere where such guardianship is necessary. The Betreuung is not necessary where matters of an adult can be handled by an empowered person or another agent as much as through a betreuer. The principle of necessity requires for appointment of a betreuer the concrete finding by the judge, in fact, that it is necessary because the person relies on such help and that less grievous measures are not in question. The need for Betreuung does not only result from the subjective inability, that is, the need for Betreuung. On top, there must be a concrete need for appointing a legal representative lacking other help. If and for what spheres of competence such an objective need does exist, shall be ruled on because of the concrete life situation of the person concerned. However, a concrete, acute need for action is not absolutely necessary. It shall suffice that the need may come up at any time, and that in this case, the established concern exists that without having Betreuung, the necessary things could not be done. Where the person concerned in Day's way was fit to act personally, has granted an enduring power, that is basically in the way of appointing a legal representative. If there's a controversy about the validity of the enduring power, if that can be revoked or if it's validly granted, then nevertheless, Betreuung may be necessary, where the controversy curtails the acceptance of the enduring power in legal relations because there are justified doubts about its validity. Where the agent exercises the powers against the interest of the principal, a control monitoring and controlled Betreuung may be ordered, or extending the scope to claiming rights of the person concerned against his representative, or ordering a revocation order. The authorization of the betreuer for revocation of the power is a grave state intervention into the self-determination right under Article 1, Para 1 of the Basic Law, which is why the intervention shall be measured against the Basic Law right, and it does require a separate court finding that this is necessary. The authorization is not contained in the standard domain of the betreuer or in the control betreuer either. It has to be allocated as a special case. A court ruling with revocation of the powers is only justified to avert a risk for the person concerned. The revocation of the power, therefore, can only be assigned to a betreuer if sticking to the powers granted, the enduring powers, would probably violate the interest of the person concerned with a considerable gravity, which normally shall be sorted out in the course of a control monitoring. A few comments on the appointment of a natural person, subsidiarity, to the professional betreuer. Under Section 1897, basically, a natural person shall be appointed the betreuer who is apt to legally do the affairs of the person concerned in the defined manner and to personally look after him in the required scope. Both the suggestions of the person concerned shall be heeded and his relatives and relations. Where that person suggests a particular person to become the betreuer, Section 1897, Paragraph 4, Clause 1, gives the fact the factual judge no discretion in choosing the betreuer. That person shall be appointed who the person concerned wishes. The will power can only be disregarded where appointing the person proposed would counter his own welfare. Where the person has not proposed anybody as the betreuer, in the choice of the betreuer, the family relations shall be heeded of that person concerned, in particular his personal ties. Where a person is not suitable for individual domains, as suggested by the person concerned, he's not fully ruled out of that action. 1899 of the Civil Code specifically provides for the opportunity of providing several betreuer, either for the same or for various domains. The legislator, effective 1 January 1999, specifically pointed out that appointing a professional betreuer is subsidiary. Those who professionally exercise the adult guardianship shall be appointed legal representative only where there is no other person that is fit to do it and can do it as a volunteer, which occurs very often, as you will know from practice. Some words on the content and the scope. With the introduction of the new law, the legislator laid down the scope and the duties in Section 1901. 1 January 1999, the new Para 1 took force, and the legislator meant to delineate that official domain of a betreuer and the additional factual commitment for the person looked after. It is necessary to identify the will and wishes of the person concerned. That often will only be managed by the representative by establishing trust, which is built up and maintained through personal affection. Such trust-building, trust-maintaining measures can therefore be part of the activity of the personal representative if they're necessary to establish the will and to represent the personal interests. That is to say, if they're suitable and necessary, and they are not disproportionate to the objective. Let me briefly talk about the Advance Directive or Living Will and the Betreuungscode to approve. 1st of July 2005 and 1st of September 2009, the provision was reworded in 1901A of the Civil Code. The legislator thus took over the effective Advance Directive into the law. This provision is closely related to Section 1904 in the Civil Code upon the approval by the court where there are grave medical measures concerned. Under 1901 Para 1 of the Civil Code, the consent of the representative needs the approval of the court where an examination is to be made, or medical treatment is to be made, or medical intervention is to be made, where there is the reason, substantiated reason, that the person concerned would die from that measure or suffer a long-term or grave medical loss. Without the approval, the measure may only be performed where there is a risk at postponing. Effective 1 September 2009, this provision by Paras 2 and 5 was supplemented. Under 1905 Para 2 of the Civil Code, the non-consent or the revocation of the consent by the representative to such a measure requires the consent of the court if the measure is medically indicated and there is the substantiated risk that the person concerned would die if it's not performed or would suffer a grave health risk or loss. The approval under Paras 1 and 2 shall be granted by the Court of Betreuung if the measure falls in line with the will of the person concerned. A court approval, however, is not required then if between the representative and the treating physician, there is agreement that the intended intervention is in line with the will of the person concerned. That will always be the case, where the person concerned has laid down his own willpower in an effective advance paper, an advance directive, which addresses the concrete treatment and living conditions of that person. Both a representative and also an agent has to verify first if there is an advance directive by the person concerned that's laid down in the meaning of the legal definition, and if that addresses the concrete situation of the life and treatment. In so doing, the agent shall also query if patient wishes still are tantamount to the will of the affected person, that is, if that still is the case, which includes the examination if the current conduct of the person who is not fit for making decisions any longer gives concrete points of reference that, given the circumstances now, he doesn't want his written will to be applicable anymore, and where that situation in his life was considered in his own determination. Where there is an effective will by that or advance directive that meets the present situation, the person concerned has taken that decision himself. The representative or agent are only called upon to take that into effect and to make sure that his will is heeded. The intended measure shall then be discussed by the representative with the treating physician. Where, however, there is no valid advance directive in the meaning of Section 1901A, para 1, the representative or agent shall establish the presumed will or possible treatment request and decide upon that foundation. Treatment requests, for instance, could be all utterances by the person concerned that are findings for a concrete situation of circumstances or treatment, but do not match the requirements of an advance directive because they were not in writing, were not anticipatory, or were taken by a minor, not an adult. Like where there is a written advance directive, it shall suffice for the identified treatment wishes. That would not suffice if it is confined to general content only. The presumed will of the person affected shall be focused on where you can't find a will of the person concerned geared to the actual living condition. The presumed will shall be identified because of concrete points of reference, in particular verbal or written statements, ethical or religious convictions, or the personal values that the person holds. The representative has a hypothesis how the person affected would have decided in the particular situation if he could have determined himself. Let me now address a few words on forced hospitalization in closed institutions and forced medical measures. But the new regulation of Betreuungslaw 1 January 1992, the legislator created the preconditions for hospitalization under civil law by the representative in 1906. Under paragraph 4, the rules apply mutatis mutandis if the person concerned is in an institution, a home or other institutions, without being officially hospitalized and is held by mechanical devices, medication, or other ways where his deprivation of liberty occurs over a longer time, the so-called measures like hospitalization. According to that provision, the person shall be hospitalized by a principal or by an agent only, and that is only admissible where it is necessary for the welfare of the person concerned, either because of a psychic illness or mental or psychic impairment. There is a risk in that person concerned that he would kill himself or cause significant detriment to his health, or because in order to avert a considerable loss, medical treatment or an examination of his health is necessary, or medical intervention is necessary and cannot be done without hospitalizing the person, and where the person concerned, because of psychical illness and mental or impairment, is not able to recognize and have insight and act accordingly. Given those preconditions, hospitalization is only possible with the consent of the court of Betreuung. Contrary to the hospitalization under public law, the civil law hospitalization by the legal representative or agent under Section 1906, para 1, number 1, that is acute, does not require an acute imminent risk for the person concerned. What is necessary is a serious and concrete risk to life or limb. The degree of risk shall be assessed in relation to the possible loss without such deprivating measures. The risk does not provide a targeted measure of the person concerned, so that total self-neglect would be sufficient if that leads to a health risk through personal decay. This requires objectified, concrete points of reference that a considerable loss to his health would occur. The approval of hospitalization must be necessary, where the risk can be averted by other means than deprivation of liberty and hospitalization. That is not in question because it's disproportionate. Alcoholism as such is not a psychic illness or mental or psychic impairment within the meaning of 1906, Para 1, number 1, so that this alone cannot be used to approve forced hospitalization. As little can the risk of relapse lead to ordering hospitalization by force. Something different would apply only where alcoholism is a direct cause for or indirectly related to a mental illness, in particular a psychic disease, or where a state has occurred due to alcoholism that has reached the extent of a mental deficiency. Hospitalization treatment under 1906, Para 1, number 2, is admissible only where it is necessary for the treatment, which cannot be performed without hospitalization, and where the person concerned, because of his psychic illness, does not have insight into the need or cannot act upon that insight. Since hospitalization under that provision is not tied to the close and narrow constraints under 1906(1)(1, the proportionality principle shall apply as the corrective against the intervention with the right to freedom. Necessary for consent by the representative to hospitalization for the treatment of the person concerned is that his domain concerns the definition of his residence, and specifically hospitalization and health care. In the end, hospitalization for medical treatment is only fit for approval if there is a promising prospect for such cure. This provides either the natural will by the person concerned to accept or the legally admissible overcoming of any contrary will by means of forced medical treatment. That takes me to what Professor Paulus addressed. If medical forced treatment can be permissible against the will of the person concerned, was controversial after the Betreuungs- and Hospitalization Law became effective September 2009. The Federal Supreme Court followed that 1906 did provide that if the person concerned could be hospitalized for medical treatment, he could also be medically treated against his will. That jurisdiction was given up by the Federal Supreme Court with a view to the contrary jurisdiction by the European Court of Human Rights and the Federal Constitutional Court rulings. In the year 2012, BGH ruled that a legal foundation for forced treatment is lacking. The legislator under the jurisdiction of the Federal Court was entitled to make possible forced treatment against the natural will of the person concerned if he has no insight into the severity of his illness and does not consent to the treatment because he lacks insight. Materially speaking, the principle of proportionality, however, requires that measures of forced treatment can only be used where they are justified with a view to the objective of the treatment that is promising. Forced measures may only be used as a last resort where no milder means are promising. On top, the forced treatment, to the extent that the person can converse, will be preceded by a serious and time spent without pressure, with attempt, that is, to obtain his confidence, his consent based on confidence. And furthermore, it was necessary to document any forced treatment. Neither the rules on guardianship or hospitalization were living up to the constitutional requirements regarding medical forced measures. Jurisdiction by the Federal Constitutional Court said that such a measure must be determined and defined in such a way as this is possible along the nature of the conditions of life. For the person that's hospitalized currently or potentially, and for the decision makers that chiefly are called upon to exercise the standard as the Betreuer, the legal representatives, the hospitals, the physicians, the law must directly say what the preconditions are. In consequence of that ruling, the legislator, as we heard with the law on amendment of guardianship law on 29 June 2011, effective July, did create the material and formal requirements of forced medical treatment. On the basis of that statutory provision, the BGH, meanwhile, further sorted out the preconditions for forced medical treatment. And so far, I will not address all the details. That would go beyond my scope. But permit me some final remarks on the question of outpatient forced medical treatment. On top of the medical forced measures in the scope of hospitalization, the law offers no opportunity of outpatient forced treatment, no medical treatment without hospitalization of the person, that is to say. This leads to loopholes in adult protection, and the Federal Supreme Court in the past pointed that out several times. The statutory provision of Section 1906 of the Civil Code has a narrow concept of hospitalization with deprivation of liberty and does not encompass non-patient, outpatient treatments. Cases had become pending, not just one, several, where inpatient forced treatment would only live up to constitutional requirements to effective adult protection. The BGH, by order of 1 July 2015, submitted such a case to the Constitutional Court. A 63-year-old affected person suffered from schizoaffective psychosis, and that's why was under Betreuung since 2014. The domain of the legal representative encompassed care and health and the consent to medical treatment, interventions, and determination of residence, including hospitalization or similar measures. In 2014, she was diagnosed with breast cancer. Further examinations and the treatment were refused, influenced by her psychotic disease, were refused by her. Preconditions to hospitalization under the jurisdiction were not given following the narrow determination by the BGH because she couldn't leave the hospital. But the person concerned, because of her schizoaffective psychosis, was neither in a position to decide with her free will about medically necessary treatment. So under the law, there was no option to operate to forcibly treat her. The law did not permit anything against her will. The BGH saw a violation against the constitutionally indicated effective adult protection and submitted it to the Constitutional Court. The Constitutional Court, as Apollo said, recently responded and ruled that the basic law to life and physical integrity in Article 2, Para 2, is not a subjective defense right only, but also creates state protection duties. Those that have no insight, that are under representation, oblige the lawmaker to provide for a system of care and protection. Medical examinations and medication and treatment must in grave cases be seen as an ultima ratio, even overcoming the countering natural will of the persons concerned. That should be legitimate. The state protection to help the helpless is outweighing the right of self-determination of the persons concerned and their physical integrity, where the medical measures that go hand in hand with averting the danger do not lead to any particular treatment risks, and where there's no robust reference point that refusing treatment would be tantamount to the original free will of the person concerned. Given those rulings under the constitutional law, the legislature will now address the requirements for forced medical treatment without the free will and possibly come up with legal amendments. As you can see, Betreuungsrecht has not been closed and complemented. There are new points of reference time and time again. Thank you so much.